Welcome back to our presentations on Mastering Trial Advocacy. Right now we're on page 358 in the text of the second edition. We're going to talk with you about some of the fundamentals of impeachment and identify some tricks and techniques of the trade that you should consider as you're conducting impeachment. Let's begin with the overview of the primary methods of impeachment. Now, there are as many methods of impeachment as there are authors of advocacy texts. We like to focus on 7 primary methodologies because they're tied to the common law and the evidentiary code. And remember, impeachment is a subset of cross-examination where the law empowers us to do more than we might otherwise be able to do. Sometimes it also limits us in what we can do. So when I think of impeachment, I think of prior untruthful acts under Federal Rule of Evidence 608B, prior convictions under 609, prior inconsistent statements under 613, bias, prejudice, or motive to lie under the common law, also analogous to relevancy under 403, defects in capacity to observe, recall, or relate, again, both a 403 question and potentially a competency of witnesses question, but usually it's just 403. And then impeachment by contradiction, which at the common law was allowed and is analogous to Federal Rules of Evidence 401, 402, and 403. And then finally, impeachment by omission. And that's also found within the doctrine of the Federal Rule of Evidence Article 4, specifically 401 and 403. So these are the 7 primary methods of impeachment. The thing that I want you to remember about them is that you can underline prior untruthful act because that's the only one where you are prevented from admitting extrinsic evidence if the witness lies about the bias or motive in question. And that's because whether or not the witness is a truthful person or has lied in the past is a collateral matter to the trial at hand.
When we talk about impeachment, what we're really talking about is dealing with issues of witness credibility. And the first thing that we need to talk about is this idea of bolstering. Say, for example, opposing counsel gets their witness on the stand and their first set of questions is all about how this person is truthful and has never told a lie in their entire lives. The Federal Rules of Evidence tell us they can't do that because that's bolstering their credibility. Unless and until a witness's credibility is attacked through cross-examination, it is inappropriate to have those conversations. So be on the lookout for that. If the witness, however, lies during the course of their direct examination, then we want to use one of the 7 impeachment methods that we've discussed with you all and delineated in the book in order to go after their credibility appropriately. And finally, there's the idea of rehabilitation. Say opposing counsel chooses to impeach on something that may not quite be impeachment worthy. In redirect examination, I have the opportunity to go back in and say that things are okay and that this works out the way we want them to.
When I think about impeachment, I want to ask myself, is it something I should do? The great Terry McCarthy describes impeachment as fishing on the side of a pond. And when you go fishing, you have a beer in one hand and a rod and a reel in the other. And every time you decide to reel a fish in, you have to put the beer down. And what Terry would tell you is that make sure the fish is big enough that it's worth putting down your beer before you reel the fish in. So how do you do that? Well, ask yourself, has the witness's testimony factually hurt my case? Has it factually supported my case? If it supported my case, maybe I'll let that impeachment issue lie because I want the jury to believe that particular witness is credible. And then I have to say, will this impeachment method destroy the credibility of the witness in its entirety or only as it relates to certain issues? So, for example, if the impeachment method is bias, motive, prejudice against or for a party, that might cut against some facts but help me with others. I have to have thought about that and think it out. And then I need to know is, can I do it? The only thing worse than not doing an impeachment is doing an impeachment poorly and losing that particular battle. And then I want to think about what the jury thinks when they look at the impeachment. Do they believe it is significant or do they see it as a trick? Because if they see it as a trick, I don't want to waste my time. And then finally, how does that witness present? Are they primarily truthful from the jury's viewpoint, or are they untruthful from the jury's viewpoint? Understanding where the witness fits in the arc of the trial can be really helpful in assisting me in deciding whether or not to impeach to begin with.
Let's talk about using prior convictions for impeachments. This is under Federal Rule of Evidence 609 and the relevant rule analogous in your particular jurisdiction. We want to make sure that we start a cross-examination with this conviction if we have a witness who is subject to those rules under 609. And we want to make sure that we take particular note of the type of jurisdiction that we're in so that we're going as far as we can go. For example, federally, you can get into what type of charge it was. You can get into that it was an assault, that it was something else. Whereas in the jurisdiction of Florida, all you can say is you're a convicted felon. Then you can go through the process of entering the authenticated record into evidence, which is an exclusion under the hearsay doctrine as a public record. Then finally, the other option is to have somebody who was present when the conviction took place come in and talk about that conviction if the witness fights you on it. Think about which one's worth the most bang for your buck. If you have a defendant or a witness who has a rap sheet as long as a mile, it might be worth it to get that authenticated record of conviction in order for the jury to see the sheer weight of those felony charges and convictions that have been obtained by that witness in judging their credibility. Whereas if the witness is going to be somebody who's going to play ball and play fair, simply asking them the question may be enough. My absolute favorite method of impeachment is an impeachment by omission. An impeachment by omission is used all of the time in federal court, but you may want to make sure that you take some note of caution and look into how it's viewed in your jurisdiction. Because in certain jurisdictions it may be viewed as you having not gone through your discovery method appropriately in order to elicit the information. But an impeachment by omission occurs when a witness states a fact for the very first time at trial, and it's an issue that's so material to the case that without it, your entire cross-examination, your entire closing argument, the legal theme and theory of your case has now been changed fundamentally by the appearance of this new fact. You need to make sure that the witness who says this fact has either made a prior statement or had an opportunity to make a statement. And then you proceed as follows. Witness, you just testified on direct examination. Da-da-da-da-da. I want to talk with you a little bit about that. This isn't the first time you've made a statement. You gave a deposition in this case. You were there. I was there. There was a court reporter there. She wrote down every single word you said. You know that. You know that because you had the opportunity to review that document, to review what you said, to make sure that it was thorough, that it was accurate, that it was complete, that you said everything you needed to say about this case and this topic. Then you're going to walk over to counsel's table, you're going to pick up your copy of that deposition, you're going to walk back up to the witness stand and say, here's that deposition. When you find where you said what you said on direct examination, you look up at me. Now, depending on the witness and depending on the mood in the courtroom, use your situational awareness to decide how far to extend the next process. What I like to do, I like to go back to counsel table. I straighten my papers, have a moment with my co-counsel, smile at opposing counsel, maybe a little like a shark, and then I'll turn back around. Can't find it, can you? It's because it's not in there. Because that's the first time you've said it was here today. You've never testified to that previously. Walk back up, retrieve the document, and move on with my case. Impeachment by omission is a way to say to the jury, this person is using your time to take the opportunity to say something they have no basis in fact to say.
I want to talk with you now about impeachment with a prior inconsistent statement. The idea behind this is that when a witness testifies in court about a particular matter, if they have made a statement previously out of court and it's not consistent with the in-court testimony, we're allowed to confront them with that previous statement for purposes of credibility. That earlier statement may not be admissible substantively, that's a separate hearsay question, but it is admissible under Federal Rule of Evidence 613 to show that the witness has changed their story. And when I'm impeaching with a prior inconsistent statement, I want to focus on three primary pieces of it. I want to credit the earlier statement. I want to commit them to their in-court testimony, and then I want to confront them with the inconsistency. Now, the commit and the credit can kind of flip back and forth as to which one you do first. depending upon how the impeachment is going and what your perception is of what will work best with the jury. The confrontation, though, is usually the last piece because that's sort of the penultimate moment. So when I credit the earlier statement, I am looking at the circumstances surrounding that statement that make it more believable and more credible. Might be time, might be place, it might be circumstances. You look at when it was made and the way in which it was made, and you draw your crediting questions from there. So, for example, a sworn statement that was made earlier, ma'am, you gave a statement, you wrote your name to it, and you took an oath under penalty of perjury that that statement was true. And you gave that statement long before you testified at trial, here's the date, and then give the date. That would be an example of crediting a sworn statement. A statement given to police that's just written by hand the night of the accident. Ma'am, you gave a statement to the police about this issue the night the accident occurred. The events were fresh in your mind. You'd just seen the accident. You wanted to give that statement. You stayed to give that statement, and you wrote that statement out by hand. That's an example of crediting a police statement. You look at the circumstances of how the earlier statement was made. When I commit them to the in-court testimony, that's very simple. I just heard you say on direct examination X, Y, or Z. You say that, and they agree, you've now set the hook, and it's time to credit and then confront with the inconsistency. And the confrontation at the end is, you said X today, you said Y before. And then, if you watch TV or a movie, so which is it, ma'am? Which is the lie? No, you don't do that. Not in the real world. You don't do that. What you do instead is you shift to another theory of impeachment that shows their bias, motive, prejudice, or personal interest to explain the reason behind the lie. And then you make that argument to the jury in closings when the witness cannot respond. I want to talk with you now about impeachment by contradiction. Impeachment by contradiction is similar to impeachment by omission, but there is a difference. In impeachment by contradiction, unlike impeachment by omission or unlike prior inconsistent statement, we have a statement that's either in court or somewhere else that contradicts the in-court testimony, or an action that contradicts the in-court testimony. And it has to contradict the in-court testimony on a non-collateral matter. It's a contradiction that calls into question the veracity of what's been said under the testimony. The idea being that you act consistent. It has to be a material issue to the case, and you are allowed to cross and offer extrinsic evidence through cross or other witnesses. If you'll think back to the O.J. Simpson trial, if you'll remember what happened when F. Lee Bailey initially confronted Mark Furman about the use of the N-word, Mark Furman's denial of the use of that word, and then their establishment of the bias of Mark Furman and his manipulation of the investigation of Mr. Simpson, they laid the groundwork for impeachment by contradiction, allowing them to provide extrinsic evidence of times when Detective Furman had used that word. And many of us looking back on that particular trial think that was the moment, along with the trying on of the gloves, that sealed the deal against the prosecution.